Good afternoon. My name is Winona Bomar. I'm a student attorney representing Ms. Giana Ellis, the Tulane Environmental Law Clinic. I'm speaking this afternoon to address the public trust duty which requires LDEQ to protect, conserve, and replenish the natural resources of the state, as well as the health of its inhabitants by conducting a thorough public trust review. If the application is approved, LDEQ will breach its duty as a public trustee because the application is 1, not avoided the environmental impacts to the maximum extent possible, and 2, has a cost-benefit analysis that is not adequate. We request LDEQ to deny permit application. First, under its public trust duty, LDEQ must assess the potential and real adverse environmental effects of the proposed facility and ensure they are avoided to the maximum extent possible. St. Charles Clean Fuels, the permit applicant, fails to properly identify the adverse environmental effects of the proposed facility. For instance, the applicant underestimates their emissions calculations. As my colleague J.R. Greenwalt will address, these conclusions come from a review by air expert Ron Sahir, who found serious deficiencies in their application. Additionally, the calculations provided by the applicant for criteria pollutants are also likely too low, and the facility would likely be a major source. These pollutants would worsen already severe pollution-related respiratory issues in Falconsville, higher than 96% of the rest of Louisiana. In addition to the odor nuisance ammonia poses, the proposed facility would create a greater risk of disaster in the event of ammonia leakage, spills, and fires. Second, the public trust duty requires LDEQ to conduct a cost-benefit analysis of the environmental impacts, balanced against social and economic benefits that the facility purports to provide, and determine if the benefits outweigh the adverse impacts. However, the applicant relies on empty promises to appeal to the community of St. Louis. Job growth is one such empty promise. As my colleague Giana St. Julian will expand upon, a recent study found zero link between parish level job growth and industrial tax exemptions, which the applicant perceives. Here, the costs are paid by the local community, while the benefits are seen only by St. Charles Clean Fuels. Furthermore, the cost of approving this facility would come at the expense of the state, of Louisiana at large, and rising healthcare costs due to pollution. An EPA assessment tool shows the proposed facility would increase particulate matter and pollutants that lead to ozone. Estimates indicate the total health effects would cost Louisiana anywhere from $3 to $4.7 million in healthcare costs due to this pollution. Louisianans will bear the healthcare costs when these emissions increases. LDEQ has a duty to protect Louisianans from shouldering the costs of these empty promises and disastrous risks. For these reasons, we request LDEQ to deny St. Charles Clean Fuels application. Thank you.
Hello, everyone. My name is Giana St. Julian. I'm a researcher at Tulane Environmental Law Clinic, address 6329 Forest Street, Louisiana. I'm here to request for fine community empowerment to provide information related to the economic impact of the proposed chemical plant. It's important that LDEQ consider some of this economic data when making decisions related to this project, and the data showed that his plant is a bad deal for St. Charles Parish. According to St. Charles Clean Fuels Industrial Tax Exemption Program application, this chemical plant will create significantly fewer jobs than what they stated in their initial Louisiana Economic Development announcement in April of 2024. In fact, there are now 32 less jobs than their original estimates, and the chemical company hasn't explained what happened to these missing jobs. For all we know, these job numbers will continue to drop, and regardless of the droppers, there is no guarantee that a single job will go to a resident of St. Charles Parish, made up. One of the secretary says these companies not kept bordered in Louisiana, and the CEO lives out of state. Yet, these supposed jobs are accompanied by over $46 million per year in industrial tax exemptions, meaning St. Charles Parish will lose out on over $250,000 per job each year over the life of this contract, which is expected to last up to a decade. The lost revenue is triple the estimated average salary for these supposed jobs. The company's air permit application makes a big deal about all the indirect jobs that will be created to support their employees. But if the employees live outside St. Charles Parish or Louisiana, those indirect jobs will go elsewhere, while St. Charles is stuck with the lost taxpayer areas. And we know that the profits from this project will be flowing back to investors in Denmark. These St. Charles Clean Fuel tax exemptions are part of a much bigger problem that can be seen throughout the parish and state. A recent Louisiana legislative auditor report found that industrial tax exemptions cost local governments in Louisiana about $1.5 billion in lost revenue annually, including over $100 million in lost revenue in St. Charles Parish. LDEQ must also consider that the people getting these jobs are not the same people who will have to breathe the toxic ammonia emissions from this fish. All right, yep. I recently co-authored a study that's looked at the racial breakdown of the chemical employees in Louisiana using data from the Equal Employment Opportunity Commission, also called the EOC. We found that people of color get less than a quarter of the good-paying industry jobs in St. Charles Parish, right? Even though they make up 1/3 of the working age population. And the community that will be exposed to the most ammonia from this plant is Elkinsville, which is virtually 100% black. LDEQ must rely on this data to make its decision, not empty promises fueled by foreign investors. So when a chemical company promises a relatively small number of jobs, LDEQ must consider that these jobs will not be distributed equitably and will cost the parish millions of dollars, while profits and jobs leak outside the economy to benefit people in other states and countries. Thank you.
Good evening. My name is Clara Potter, and I'm a supervising attorney and clinical assistant professor at the Tulane Environmental Law Clinic here tonight on behalf of our fine community empowerment. And we'll also be submitting a comment on behalf of the Sierra Club, concerned citizens of St. John, the Green Army, and the Descendants Project. Before talking about why we believe this permit should be denied, I want to address why we believe LDEQ should recuse itself from making the decision on this application, and should have addressed the pending motion for recusal that we submitted on November 1st before holding this hearing. There are two primary reasons why LDEQ must recuse itself from this permit decision, both of which relate to statements that the LDEQ made after the last hearing on October 26th. Before that hearing, DEQ was put on notice that the venue was too small to accommodate the public interest in the project. And when the rebuilt mass capacity, DEQ did the right thing that night by adjourning the hearing and saying that they would reschedule. But days later, in the statement to the press, DEQ held the events at that hearing unacceptable and an organized attempt to hinder economic growth and prosperity for the state and local communities. Not only is the statement false, but it warrants recusal for two reasons. First, the statement strongly suggests that DEQ has prejudged the key fact in this dispute and has already decided to grant the current report of unfolding a public hearing or receiving all valid. As part of its covered trust duty, DEQ must weigh the benefits and the cost of a project before making a decision on the permit. Specifically, it must determine that the environmental impact costs are outweighed by the social and economic benefits. Tonight, you'll hear detailed comments from my colleagues and community members about why the costs of this project are clearly not outweighed by the benefits. And so I ask you, can LDEQ weigh this evidence fairly when it has already decided that this project will, quote, support economic growth and prosperity? And second, LDEQ should recuse itself because even if it hasn't decided whether the benefits outweigh the costs, its public statement has eliminated the appearance of complete fairness in these proceedings. The public in St. Charles fields both have a right to an impartial decision maker on this permit. When DEQ labels residents' reasonable attempts to participate in a public hearing as unacceptable and an organized attempt to prevent their own community's prosperity, it suggests that DEQ is biased against those community objects. And so again, I ask, can LDEQ fairly hear their concerns tonight, and does DEQ value their input as much as the input of St. Charles fields? Right. I kept tally while people were speaking, and I only heard one person who lives within a 2-mile radius speak in favor of this project tonight. The folks here tonight deserve a fair decision maker on this permit. So we ask that DEQ rule on our pending motion to recuse itself. And because DEQ is holding this hearing here tonight, I will briefly comment on one aspect of why we think this permit should be denied, which several other folks have already commented on, which is the carbon capture. Is the facet of this application. St. Charles Fuels claims it will capture over 99% of its carbon dioxide emissions No facility to date has come anywhere close to this. And more concerningly, there's nothing in the application about the CO2 pipeline for Class 6 well, which posed tremendous risk to the community. And finally, we ask that DEQ deny this application, and I would like to submit as an exhibit into the record the introduction of the 3 student attorneys who will be speaking here tonight with the clinic: Winona, Bomar, J.R. Greenwalt, and Sidra Hansen. Thank you.
Good evening. My name is Sidra Hansen, and I am the student attorney also representing Ms. Giana, the Tulane Environmental Law. As my colleague stated, LDEQ has a constitutional duty to act as a public trustee of the environment. This is not a passive duty, but one through which LDEQ must actively and affirmatively protect the rights of the public. In addition to adverse effects and costs and benefits, the public trust doctrine requires LDEQ to consider alternative sites. St. Charles Clean Fuels alternative sites analysis is superficial at best and deceptive at worst. An alternative sites analysis asks whether there is anywhere else this facility could go that would be better for people and for the environment. This is an air permit application, but St. Charles Clean Fuels alternative sites analysis is silent about air quality impacts. It does not talk about how close the different sites are to other sources of air pollution, and it does not discuss whether communities at the different sites are already overburdened by pollution, like St. Rose and especially Openspell. Under its public trust duty, LDEQ must serve environmental justice, which means considering Elkinsville's already disproportionate pollution and burden. Several members of the Elkinsville community have talked tonight about the pollution that they already experience at home because of IMTT. People hanging their clothes outside and noticing that they have a chemical smell and they take it back in. Our client unable to sleep at night and having to leave St. Rose to stay in a hotel because of the fumes in the air. LDEQ must consider air impacts in its alternative sites analysis. The factors that St. Charles Clean Fuels does consider are flawed and incomplete. First, many of the necessary criteria to make this project happen also exist at other sites, like river access, industrial zoning, and CO2 tie-able. Also, St. Charles Clean Fuels application claims that the St. Rose site is sufficiently isolated from the public, but its own maps show parts of the facility crossing the 2,000-foot residential buffer zone that is required by the parish. Not only do several of the alternative sites lack this extreme residential proximity, but the residents in this room tonight show just how many people would be impacted by this facility. Additionally, other sites are not true alternatives. The Riverplex site, for example, is the proposed site of the new CF Industries Blue ammonia complex. Furthermore, St. Charles Clean Fuels claims that the St. Rose site would not impact cultural resources, but its maps erase Elkinsville's, leaving out the historic Freetown Cemetery at 2nd and Short Street. These omissions and contradictions leave it difficult, if not impossible, to meaningfully weigh alternatives under the public trust doctrine. However, even this piecemeal analysis suggests that other alternative sites are better offshoots, or at the very least, that the same things are here that cause St. Charles Clean Fuels to reject alternative sites. For these reasons, we urge LDEQ to deny this air permit application. Thank you.
Yeah. My name is J.R. Greenwalt, and I'm here tonight as a student attorney for the Tulane Environmental Law Clinic, speaking on behalf of Ms. Giana to urge LDEQ to reject St. Charles Clean Fuels permit application. LDEQ should deny this permit for 2 reasons, which are based on the analysis of an air expert, Dr. Ron Sabu, whose report we will attach to our written comments. First, SCCF is very likely a major, not a minor source of criteria pollutants, so it must comply with the requirements for major sources. And second, SCCF almost certainly underestimated the impact of its ammonia emissions on nearby communities like Elkinsville. To my first point, SCCF's emissions calculations vastly underestimate its potential emissions, in part because they use improper emission factors. For instance, SCCF uses emission factors which are average figures to calculate its maximum potential emissions. a practice that EPA itself has criticized. SCCF also uses emission factors based on what it claims is a similar facility, but it does not name that facility or show that its chemical processes are in fact similar. Dr. Sabu concluded that proper calculations would reveal that SCCF is a major source for multiple criteria pollutants. Now, why does it matter so much whether SCCF is a major or a minor source? Because major sources must comply with extensive Part 70 regulations. For one thing, to comply with these regulations, SCCF would need to do a more thorough analysis to show it complies with the best available control technology. In his expert report, Dr. Sapu identified several instances in SCCF's application where it should have evaluated using safer, more stringent emissions controls. These failures demonstrate a lack of regard for the health of residents of communities like Elkinsville and St. Rose. Coming to compliance, SCCF would need to evaluate using safer technologies. To my second point, SCCF's application also underestimates the impact its ammonia emissions will have on nearby communities that are already overburdened with toxic industrial pollution. In its air quality dispersion modeling, SCCF estimated the ambient concentrations of ammonia already existing in the area. SCCF claimed to have accounted for all sources of ammonia emissions in a 20-kilometer radius, but it did not provide a list of the sources it considered, and at a minimum, we know it failed to include at least 13 distinct sources of ammonia from IMTT. SCCF also used reported ammonia emissions instead of permitted ammonia emissions in its modeling, which, as Dr. Sapu notes in his report, very likely resulted in underestimating the additional impact of SCCF's ammonia emissions. In sum, SCCF is likely a major source, but failed to comply with the requirements for major source applicants, and it underestimated the impact its ammonia emissions will have on local residents. These strict application requirements are not just about getting more numbers on the paper. These requirements are in place to protect the health of residents who live right next door to these facilities. The people of Elkinsville and St. Rose, and all of St. Charles Parish for that matter, are already dealing with disproportionately high rates of air emissions. LDEQ must deny this application to prevent the situation from worsening even further.